We're here with Hap May.
And this is Hap May with the Legal Play.
I'm Chelsea El-Azzi. Hap, along with being an attorney, you're also an adjunct professor.
I am.
At the University of Houston Law Center.
I am. Yes, I am.
And the course you're teaching is titled
Bankruptcy Tax.
Bankruptcy Tax. Which, your intro to the class is usually like there's really no such thing that exists.
Right. It is a area, two different areas of law that have maybe 20 points that overlap, where you kind of have to decide, does bankruptcy law govern, does tax law govern, or is there some special rule carved out of that?
And kind of the interplay between tax within bankruptcy and things like that.
You're right. And tax in anticipation of bankruptcy, tax during bankruptcy, tax after bankruptcy.
Which actually, there's quite a lot of that. I think it's very relevant.
Quite a lot. It's very relevant, and a lot of times there's a lot of money involved. When you get into bankruptcy, you always see that there is, this pool of assets and this many creditors. I gotta get in the screen here, but this many creditors in the process. So not everybody is going to get paid. So there's usually a fight amongst the creditors.
Okay, and one of those creditors may be the IRS.
Quite often is.
So, in the first class of your bankruptcy tax class, your students have a case that they are to read to prepare for class that day. And I'm not sure how you pronounce this guy's name. Berger?
We've pronounced it Berger.
Berger,
but and I suppose it could have a French pronunciation too, Berger.
Okay. Versus the IRS, it's Begier. Versus the IRS, and it's a case from dated out of 1990, so slightly older case, but
still very applicable.
Right. I mean, that's in the case book for a reason.
Right.
So I did read it, and I had to summarize it a little bit in preparation for this podcast. But we have America International Airways, AIA,
right,
which was an airline.
Was an airline.
And it as an airline was an employer. It had a lot of staff and employees under its umbrella.
Right.
And
also had some employment taxes and some excise taxes.
So as an employer, it's required to withhold FICA taxes to be held in a special trust.
Yes.
And what actually kind of confused me when I came on and started hearing about these trust fund taxes is when I think of trust fund, I think of like an actual a trust that a personal
sets up for your children, so that yes.
Right. And so when I was like, why is the IRS coming after all these employers for trust fund taxes? Do all of these employers have these personal trusts set up for their families? And why is this a big deal? And then you had to correct me. And
it's a trust is basically somebody holds something for the benefit of another, and that's a trust.
Yeah, and so in this case, trust fund taxes in this context are employment withholding taxes.
Well, in this case, they're employment. So you are my employee, and so I pay you. But I'm supposed to pay you $1,000, but somehow you only get like $800. And the reason of that is I hold this extra $200 out, and I pay the government with it. And obviously, just for those at home, that's not how much she gets paid.
No.
Not really. This is just an example.
I do get more than that. But basically, instead of me paying my own income taxes,
income taxes and the Social Security tax, the FICA taxes, Social Security, Medicare, those kind of taxes, which so the employer collects theoretically. I'm supposed to pay you again $1,000, but I withhold $200 of that, so you get a net check for $800. Now I'm holding $200 in trust for the United States Treasury. And I have to pay that over. I pay the employees portion of FICA, which I think is still 7.65%. So that'd be $76.50, and then I'd have 124 to pay your actual federal income tax withholding.
Here's the accountant trying to do the numbers in his head.
I'm withholding that, and then additionally the employer has to pay the employer's portion, which is not part of the trust fund. But I have held it. And the same thing I think was talking about, that they have customers that have paid for which there's an excise tax. Supposedly the customer pays the excise tax to the airline, and the airline has to then hold it in trust and pay it to the government.
So the fact pattern in Berger that they have the trust fund taxes, and then the airline fell behind in paying these trust fund taxes.
Happens more times in business than it should.
And the IRS was aware, and AIA, the airline, was in communication with the IRS about paying these taxes, and then they're not doing well, and they're getting ready to file Chapter 11 bankruptcy.
Right.
For about 90 days, AIA operated as a debtor in possession. So it's filed bankruptcy, but it has
they are still management. The court has not taken that away and appointed a trustee yet.
And within that 90 days, the airline decides we're going to go ahead and make good on all of our trust fund taxes that we owe, and pays that money over to the IRS.
Right.
And after that, the court comes in and appoints a trustee to then take over.
Taking the control of the company away from existing management and placing somebody they appoint.
And I did not write down the amount, but it was a fairly large amount. It was like a very significant amount that they had that AI paid over for these trust fund taxes. That the trustee that was then appointed was like, "Whoa, that's a large amount!" And there are all of these other creditors. You know, why should that chunk have just been paid over to the IRS? And then he then starts a suit and filing motions to try to get that money.
Sues the IRS. Berger is the trustee appointed by bankruptcy court, suing the IRS.
To say, give us that money back.
Give us that money back.
That shouldn't have been paid over to you. That should have gone to all of these other creditors in this bankruptcy.
Right.
And the main holding is that the whole point of this case was that that money that was held in trust was never really AIA's or the debtors to begin with.
This is a concept in bankruptcy concept called property of the estate, or property of the debtor's estate going into bankruptcy. And money, the argument that was ultimately successful here was that because it's held in trust, it is not property of the estate, it never was the debtor's, and therefore when the debtor pays it over to the government, it is just a trust fund. Yeah. And the government got the money they were always supposed to get.
Right. And it didn't need to go back to the estate to pay to any of the creditors.
Right.
Now, that's the holding of the case. And I remember, this is like your first day going into class, and you're like, what'd you think about this case? And I was like, well, it makes sense to me because, these employment taxes that do need to go over to the federal government should have gone there anyway. And your question to me, and then I think to your class, was, okay, but if there were all of these other creditors, why did the airline choose to take that chunk of money and pay it to the IRS?
Right.
Why not?
While they were still debtor in possession, why historic legacy management, pre-petition management is still in charge. Why do they choose to pay the IRS? And the answer to why they would want to do that, what their motivation was.
Well, hang on. And because you had asked me, well, why would it? And I was like, well, because it's the federal government, it's the IRS.
They're very patriotic.
They're big.
They want to make sure the government gets paid.
Or they're just the big.
I
I feel like people get scared of anything to do with the federal government or the IRS. So it's like, okay, well, when you've got all of these creditors, you've got Joe Smith over here, and I don't know, Food Inc. and all these other things you owe money to, and then here's the federal government. You're like, oh, definitely we're going to pay off the IRS.
And it's that's part of it, but it's not that from looking at it from the debtor's point of view, that the debtor wouldn't necessarily prefer those creditors, but the management, who was pre-petition management, can have personal liability for it.
So
if I take money, if your employee, you work for a law firm, which is a corporation. Okay, you get paid, and if I am the person responsible, and I withhold the money from
the responsible party.
Right. The individual who is responsible for the companies, and I take that money, and it doesn't get paid. I allow the company to use it for something else. Doesn't mean I have to take the money. I just have to, have the company use it for somebody else to pay other creditors with it in the process. Then there's a procedure by which I can be held personally liable for those trust fund taxes.
And this is after the bankruptcy case has finished and other creditors have been paid off, or
Well, or right after. I mean, not necessarily after it's finished, but it could go on after it's finished. The IRS could pursue me at that point in time. But yeah, the IRS could come after me once it becomes apparent that the debtor is not going to pay. The company in bankruptcy is not going to pay the debt.
So just, I want to re-summarize that a little bit, because this was news to me. If you're filing bankruptcy and you've got all of these debtors, but trust fund taxes, employment wages or employment taxes that the employer needs to pay over against all of these other creditors, and you've got your bankruptcy, some of that debt can be extinguished or forgiven, or however it
right.
pans out in bankruptcy. And that's not what this podcast is necessarily going to go into, is like who gets paid in bankruptcy and who doesn't. But in the grand scheme of things, that trust fund liability on the employer's part and the responsible party's part doesn't go away. That is not a dischargeable debt.
That does not get discharged. Yes, that is something the obligation to pay that does not go away. Federal income tax, if it's old enough, can be discharged, but the trust fund taxes from employment taxes, excise taxes, and some other examples, that does not get discharged.
Okay, so let's say in bankruptcy, this business gets liquidated and the business no longer exists. Who's left holding?
The IRS will then search for
the responsible
parties.
Mm-hmm.
Now, they don't always find them. I mean, you get examples of, there was one responsible party, he died. And he died broke. Company went bankrupt, weren't enough assets to pay the taxes. The owner was responsible, the owner was broke, the owner died. I mean,
that's a sad ending to that story.
So there are situations, or sometimes I get cases where, there's one 9-figure case I was involved with. The IRS is never going to collect all that money.
Right.
But they still collect, what they can with regard to that.
But I wanted to talk about this topic because we do have a few clients who are dealing with this issue where they at least are the potential responsible parties.
Right.
And their companies did not pay over these trust fund taxes. And the IRS figured out, hey, this person is associated and might have been.
Was an officer and had ability to sign checks. Those are the two things they look for mostly in the process.
And often, if the clients have gotten that far, then they come to us. They likely were the responsible parties.
Lots of times they were. Yes. Now we make the IRS go through their procedures. Sometimes they do it right. Sometimes we can compromise. Sometimes we can, kind of get the debtor to the point where they're going to get so much from him in the process.
But what are their options? What are the responsible parties' options at that point?
They can.
Besides just paying it over, if they don't have it.
And I guess we're skipping a step. Going back to the case for a minute. The reason that the legacy managers of the debtor during the debtor in possession period, where they still had control, paid those taxes, was so that the trust fund taxes would be paid, and there would not be any trust fund taxes for which the IRS to come back against
them personally,
which is what upset the trustee a great deal. But in answer to what happens when there is somebody who has that big burden, a $10 million for which they're never going to be able to pay, they can do an offer in compromise. The IRS says, you're not going to collect all this, but, here are the assets I have. Here's what I'm likely to make in the next 5 years.
And we have done a podcast and a blog on offering compromise. So if you want to know more about that, refer to our other blog and podcast.
And I'm not big on doing those because they're a lot of work, and a lot of times the success is limited. And what the IRS says somebody can pay, sometimes they really in reality can't pay that in the process. So they could do that. They can also, cannot file bankruptcy. You can file bankruptcy, but it doesn't discharge the debt in the process. You can enter into an installment sale. You can, not installment sale.
An installment agreement
where you make payments of how much you have, how much available, and every couple of years the IRS will come and look in your situation, see if you should be paying more or something to that effect. You can, I call it kind of run and hide, where if you don't have much, and maybe you have a spouse that does earn money, and if you don't, there's not much the IRS can collect from you. Mm-hmm. I have had clients find jobs overseas, where they can function there. If it's big enough, it's criminal enough. I mean, there's the IRS can get extradition and jurisdiction if it's really that if you literally owed $100 million and tried to live on the run, they would probably hunt you down in the process. But if you owe $1 million and wanted to move somewhere and get a job, whether the IRS can continue to go after you, the IRS will have 10 years to collect, a 10-year collection statute. And during that period, they either have to collect or reduce the assessment to a judgment. I mean, they have to sue you and get which, if it's $250,000, maybe they don't do it.
Yeah.
I mean, in the $100 million case, they did it. There's another $50 million case I was aware of that they did it. Mm-hmm. In the process.
Hap is familiar with this process.
Yes.
Which I guess is part of why you are the adjunct professor teaching the bankruptcy tax class.
That I'm willing to work hard for low pay.
I feel like the big takeaway and advice we should give any of our listeners or readers of this blog is pay over the trust fund taxes. That would be good to just go ahead and pay
over the trust fund taxes.
Make that a priority in your business.
And if you can, do so before some court takes your ability to do that away from you.
Mm-hmm. Yes. And if you find yourself in a position where those trust fund taxes haven't been paid and your ability to do so has already been taken, and you're dealing with some personal liability, you know who to call.
This is Hap May with Legal Play.